Generally what happens in my court is I set certain dates. We have pretrial conferences, and I'll set dates, and I'll get into that in a little bit. But yes, you would have a date certain when the appraisal needs to be exchanged.
Certain other things that I see that to me are red flags as an attorney that, I might have an opening. Photos. If I'm reviewing a report for industrial property and there's a picture of an industrial property and a picture of an industrial property and then there's a picture from Google Earth, I don't think you've been there. I see it all the time. Whatever the property, if there's one of them doesn't have a picture, I'm going to probably ask you what was across the street. You're making location adjustments. You weren't even there. Now, sometimes that Google Earth is important because you can't get far enough away from an industrial building where the picture means anything. But again, those are things, and I think the more pictures you have, the better you can tell a story. It goes back to the first or second slide, the more persuasive you can be. Google Earth is really good if you're trying to show a whole neighborhood, how close you are to a highway, those kinds of things. When photos aren't there, it's a red flag that maybe you weren't there. If you have interior photos for 2 of your comps, and you don't have interior photos for the comps 3 and 4, well, you probably weren't inside. You don't get it necessarily inside all the comps. At least I think it'd be better to be putting more weight on the comps you really know more about. So consistency is really important. USPAP. A lot of appraisers tell an attorney, this was a USPAP violation, that's a USPAP violation. We all care a lot. I know when I'm on the witness stand, when I get asked a USPAP question, the hair on the back of my neck goes up. I'm getting upset, but then I relax, because what it means when you get asked a USPAP question, at least in my opinion, is they got nothing substantive on you. If they could blow out sale 1, they can blow out sale 2 or your leases. They're going to blow out sale 1 and sale 2. They don't need to ask you a USPAP question. If they're asking you, isn't it true that you were supposed to put it, whether it's a hypothetical or an extraordinary condition, and you're like, oh God, USPAP. I don't think that will matter to the judge at all. What matters to the judge are the facts in your report. Did you have sale 1 correct, sale 2 correct? Are your adjustments supported and reasonable? So I hate nothing more than getting asked USPAP questions, but actually that means they really have nothing big to get you with, usually. The appraisal report. For tax court, and again, any court, make it easy to follow. You can have an addenda, number your pages. When you're testifying, pause, say, look, the sale on page 27, and wait till the judge or who's ever hearing the case is on page 27, because otherwise you're talking, they're looking, you're not helping anybody, you're not being persuasive. Wait till everyone's on the same page. Don't put, I see reports that are 15 pages with 120 pages of addenda. That's really, you got all the stuff there, but it's really making it difficult for someone to follow your case, and to be a good witness it doesn't help if your appraisal's right if you're not convincing anybody when you're in court. So again, put that stuff there, reference it while you testify.
Chuck, just on appraisal reports, it happens, and it happens more frequently than you would expect, that there are mathematical errors on some calculation. And you've picked that up, your attorney's picked that up before trial, and you're going to make that correction on the witness stand, which is fine. That's very acceptable, and everybody understands that. Have the corrected page ready for the judge and for your adversary, so that when you say on page 22 there was a mathematical error, here, judge, is the correct page to put in there. You know that now it gets marked into evidence with the correct page, and it gets put into the appraisal report. And when the judge goes back to write the decision, he's using or she's using the right page. It has the right mathematical formulas that you want. So if there's a correction that you need to make, that's fine. Do it right up front before you even start testifying. We've got some corrected pages here. Put them in, and then everything flows easily. Makes our job easier at the end.
Sales comparison approach. Generally, if you're doing an income property and you don't know about the income and expenses, these are difficult sales that anyone's going to give any weight to, because again, if you don't know if the building's at market rent, if you don't know if it's full, half full, a quarter full, you don't know what the cash flow is, an investor's buying the right to collect the rent, if you don't know what those numbers are, it makes no sense that you're making adjustments because of physical condition and not economic conditions. Having said that, what I said earlier is nonetheless, sometimes they're still good to be used as a check, and apartment buildings are a great example. You might not know the actual income and expenses, but you have an idea if it's somewhat in the same rental range and what they're selling for. If you're way off your conclusion is way off what the market is showing, it is still good as a check and a good reason to go back and check on your appraisal. There's something in New Jersey and elsewhere with if your adjustments are huge, that maybe your comparable isn't comparable. It's a weird thing because I think as an appraiser, you got to do the adjustments that are supported and that you believe in. There's a lot of case law in New Jersey that said if the adjustments are 50% or more, it's not comparable, they'll throw it out. I was actually in a trial where my sale got thrown out because my adjustments, and I thought I had proved them, were 55%. And 2 days later, when the other side was presenting their report, they had a sale with an adjustment of 30%, and it got used, and it was the same property. It kind of got lost, but it was like, wait, it's either a usable sale or it's not. And what was happening is it was encouraging appraisers to, well, if I call it 45, we'll get to use it, and not calling the adjustment the way you see it. There are some cases where adjustments have been accepted over 50%. They're just not discussed. There's lots of them where there are adjustments over 50% throw out the sales. The context, something my partner tells me all the time, is everything. I've found cases where the adjustment was 50%, but it was against, sort of your interest. You're a taxpayer and you're adjusting something up 50%. Maybe it should have been up 30. The town isn't hammering you. You're raising your number. The sale gets used, and then this 50% rule goes away. I think you got to still make the adjustments as you see them, although you got to be cautious that there's a good likelihood that a sale with adjustments that big will be given no weight. This goes back to what I said earlier. Use them, do your job the way you see fit. It might be given no weight, but maybe you're giving weight to another sale, and maybe the judge might still be siding with you, not using that sale, but they could still be influenced by it without necessarily saying so.
Chuck, on the magnitude of adjustments, I have a little bit different approach to that. I look at the number of adjustments. If you adjust a sale by 50%, but it's all one adjustment, maybe it's a large land acreage compared to your subject, and you make that one adjustment, but all the other criteria match right up perfectly, then that 50% doesn't really come into being making that property not a comparable. But if you're making 10 or 15 adjustments, every little item you're making an adjustment on, and that comes up to 35 or 40%, I may look at that a little differently, because now you're really adjusting so many items, that really tell me that that comp is probably not really a good comparable. So you really got to look at what you're adjusting and what values you're associating with the adjustment.
Two points that raises to me is, one thing is you might use a sale and your adjustment's more than 50%, and there's a chance it might not be used because the adjustments are so big it might not be comparable. But maybe the judge will hear everything you say and say, you know what, I like that sale, but the judge might think the adjustment should be 30%. It still might be used. It can still help the trier of fact decide what the market value is. And the other thing is that all the judges, they're free to determine value the way they want. There's case law out there, and there's cases from judges from 30 years ago, and it's precedent, but it doesn't mean judges who are sitting today have to necessarily follow it. Those cases were based on certain facts and circumstances, and it's a guide, but it's
a guide if it's other tax court judges, decisions and opinions. If it's an appellate court or an intermediate appellate court, Supreme Court or the appellate court, and they've set down a rule of law that we have to follow, then we have to follow that. I don't think you're going to find rules of law on adjustments. But we do look at the opinions that other tax court judges, not only in New Jersey but throughout the country, have relied upon and used, and we look at them. But we're not bound by them. So if you see something that's a little different, as Chuck says, don't be afraid to put it in. The worst that could happen is we don't consider it.
Yeah, Dan.
Judge, are you considering I think it's Greenblatt Englewood?
That's my opinion.
Well, that was your opinion.
That was my opinion. You can ask away. Go ahead.
Are other judges paying attention to that? Are here, taxation boards, county taxation boards paying attention to that case?
I can't answer that question. I'm not privy to what the county boards do. I don't go to the county boards any longer. I don't hear what they're doing. I see appeals from county board judgments, and I don't talk to commissioners, so I don't know if they're looking at it. I can tell you that other tax court judges have cited it in their opinions and have followed it.
there are sometimes, we find sales between a tenant and a landlord, where the landlord sells it to the tenant. And the municipalities always say, that's not an arm's length sale. And we know the landlord, and we know that the landlord knows the tenant, but they're not friendly, and he sells it to them. We would like to use that sale. What does the court think about that?
It depends on your support, on your verification. As Chuck said before, and as I'll say in a little bit, it depends on the verification. Did you talk to the parties, to the principals? What was it? Was the sale part of a lease? Was it included that they would have a right of first refusal, or was the purchase price set in the lease if the tenant exercised an option? And then you've got to compare it to market. You have to still go out into the market and see, does that sale, as Chuck said, pass the smell test? If that sale is comparable and you make some adjustments to other sales to come in to bring it into value, yes, that sale could be used. It's not excluded, but it's got to be supported. And when you have that kind of a relationship, you've got to do a little bit greater due diligence to be able to support the use of that sale.
I often was told, I can't use that sale. We talked about that earlier. Don't reject your own sales. Put in everything. As long as you got some stuff, you can definitely, support at the end. Keep going. Ken, I know you have a question. I just want to get through. I'm running a little behind. We're now at the halfway mark, and so the judge gets to make his remarks. Let me just go through a little bit quicker, and we'll still have some time for questions at the end. And I'm going to go through some of these slides a little quicker. Sale of the subject. There's lots of cases where the sale of the subject doesn't define what market value is, but that's because the person doesn't necessarily meet the definition of market value. You would think that that would be what the value would be. Often it is, but it doesn't necessarily. You still need comps. The date of the sale, towns will often tell you that a sale must be before the valuation date. It's best that most of your sales are, but you can use sales that are after the valuation date as long as they support your other sales. Some of the things that you can discuss is, well, the contract and the meeting of the minds was before October 1st. It was on the market. Again, use everything you have, but still you need to have some sales before October 1st.